it illustrates how anything can go wrong. A disaster. It would have been very, very, very expensive. And this was a very, very scary situation. Hi there, and welcome to another exciting episode of the Conscious Counsel podcast with your host, Cory Sterling. That's me. What's up, everyone? I hope you've had a fantastic week, and I'm really excited to share a new episode today. As always, my promise to you, the cherished listener, is to provide information to help you protect and grow your wellness business with both confidence and clarity. That's what I care about. I want you to be informed. I want you to understand what actually happens in the legal world for health and wellness professionals. And I want you to have that information and feel really, really good about it. So that's my promise to you. And this week's episode is a big one, and it's a crazy story that I have to share with everyone because it happened to one of my clients and you should know about it. So I'm going to talk about why it's important that a waiver of liability has all of the different specific equipment and risks that are related to the activities that you offer. And I'm going to tell a story that happened to one of my clients that luckily does not have a bad ending, but is also a very real story and something that happened, and things like this do happen. So it's important that you know. Now, a waiver of liability is a document that is an exchange where someone agrees to participate in activities that you offer in exchange for giving up legal rights they would otherwise have to sue you. The waiver is essentially the document that prevents you from getting sued, and in the event that something happens, there's an accident, someone gets injured, something happens with the equipment, whatever it is, if and when any of that happens, you're able to go back and say, okay, well, we actually warned you about this particular risk. You knew about the risk and you still decided to participate in the activity. And as such, we're not legally responsible for any injuries that you might suffer. Now, the biggest issue in our industry, in the health and wellness world, is the waivers are never specific enough to the activities. So it'll be something general, or it'll be something drafted by ChatGPT, or that you got a template from your friend, or whatever it is. And it's not going to be specific to all the unique risks that your services offer. And if the risk that manifests, which means to say, if the thing that went wrong was not included in the waiver, you won't be protected. You just won't. If someone actually gets injured and there's significant amount of money to be claimed in damages, a good lawyer is going to be able to tear apart a bad waiver of liability. So it's really, really important that your waiver is dialed in, locked in, and has you fully protected. Now, waivers of liability, the situation will always go one of two ways. One is all of the activities that you do, everything that you offer is covered under the waiver of liability and you're protected. So let's say I'm running a retreat and we include stand-up paddleboard. Cool. On the waiver of liability, stand-up paddleboard, the risk of getting hit with a paddle, the risk of falling off, the risk of drowning, all these things are real and happen and have happened and will continue to happen. If the waiver covers it explicitly, awesome. No dramas, no issues. It's terrible that an accident took place, but we thought about the accident, the potential of the accident taking place beforehand, and we dealt with it accordingly. Now, conversely, if the waiver of liability does not cover, so if we go again with the example of a retreat and stand-up paddle on the retreat, it doesn't say anything about water, it doesn't say anything about stand-up paddle, and someone gets injured or hurt or suffers significant damages as a result of participating in stand-up paddle, then you're in trouble. And even if you're doing a yoga retreat, a meditation retreat, a business building workshop retreat, whatever it is, if the activity where someone suffers damages is not covered in the waiver, then you won't be protected. And that brings me to this week's story, which happened to a set of clients of mine who are awesome. They have a hot yoga studio on the West Coast. I'm not going to say exactly which state, but they have a hot yoga studio in the West Coast. It's hot yoga and it's hot Pilates. And one of the way that their studio is set up is that the heat comes from panels that are attached to the ceiling. And one of the heat panels, which is very, 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 very hot, actually fell down onto the floor. It didn't end up hitting anyone, thank God, but it very, very easily could have. And I think the temperature was like above 400 degrees. So God forbid, it's like being hit with a stove. And this was a very, very scary situation. And so I share the story because, firstly, it illustrates how anything can go wrong, right? The studio had been open for 8 months and it was a faulty installation. My clients did not do anything wrong. They paid a company to come install these panels. The panels were not installed correctly. Okay. There's nothing that they can do about that. But still, it's like, the way they told me the story is the panel fell and there was someone who was just got off their mat. It was the end of class, just got off their mat and was wiping their mat down and it fell right beside them, which means it's like at that point we're playing with fire. You're definitely playing with fire, where in the event that if luck goes the other way, heat panel falls on that person. And now we're definitely talking 6 figures plus lawsuit, very, very serious. Now, the waiver of liability that we drafted for them includes the risks of participating in hot yoga, including the equipment of hot yoga has heat panels of which is included. So the waiver of liability says, hey, look, you're coming into this space. These are the activities that we're doing. These are the risks of all of the different things that we're doing together. You understand there's a possibility that a panel could fall on you. Obviously, we're going to do everything we can to make sure that doesn't happen, but the risk is real. And in the event the risk materializes, you're not going to hold us responsible for any damages. And this is really important because if the waiver of liability does not include anything about falling panels or heated classes or anything like that, and you're listening to this, you never think that it's going to happen. For me as a lawyer, I wake up every day, I have new stories in my inbox, but this is the first time in, 8 years and more, drafting thousands of documents. This is the first time this particular legal issue came up, but it's very, very real. And so how it would have gone is one of two ways. If they didn't have an industry specific waiver of liability that covered specifically part of the equipment of doing hot yoga are the heated panels. And if the waiver did not include heated panels and the possibility of heated panels falling on you, then God forbid someone gets hurt, done, finished. Mostly all of your money is going to go to trying to resolve that issue or that problem. So it's a very, very real thing. Conversely, firstly, thank God nothing happened. But in the event that something did happen, in this case, the client would be able to rely on the waiver of liability and say, like, look, we're so sorry this happened. And we did everything that we reasonably could to prevent this from happening. We hired professional installation crew. They told us they did everything correctly. We have all of this documented in paperwork. There was a really bad, unfortunate accident where they, installed it in a faulty way. However, we told you that this was a risk of participating in these activities. We told you there was a possibility of suffering burns. We told you that there could be injuries as a result, and you still chose to participate. Therefore, legally, you do not have grounds against us. Thankfully, no one got hurt, so we don't have to go down this road. But if we did, that's the legal strategy that I would have implemented with my clients. The thing to remember that's about this, and this would be for another episode, or it's going a bit more complex into the problem, which is not the point of this podcast, but in the event that someone did get hurt with it and the studio was deemed to be negligent, the studio would bring an action against the installation crew and the company who installed the panels. Because at law, everything always comes down to reasonableness. So in this case, if the studio owners were reasonable, if the studio owners had hired a professional company who told them that everything was installed properly and double checked and triple checked and did all the things that they should have, and it fell, okay, it's bad luck, but it would be the responsibility of the installation company, not the studio. That won't prevent the person, the student, the yoga student who gets injured. That doesn't prevent them from bringing an action against the studio. But all it means is that the studio would be able to recover or go after the installation company, or if there were any form of negotiations or mediations or whatever it is, it would involve the company as well. So sometimes things are out of our control. It's always going to come down to reasonableness. But also in this situation, because the waiver of liability have the specific risks and the specific activities, in this case, my client, I would have had a strong legal position to stand on, where I would have said, we told you about this, you continue to participate, and as such, you can't hold us responsible. So that's this week's episode and this week's story. I know that a lot of the times I share things that even I don't believe can happen. And even having done this for so many years, there are still new things that happen. But essentially, what I want you to take away from this episode is that your waiver has to cover the equipment and the risks of your activities. And if it doesn't, you won't be covered by it. And then you'll be open to legal risk, liability, lawsuits, drawn out process, just not fun. It just won't be fun for anyone when and if that materializes and the waiver doesn't have it. So the story that I use to explain this is just a heat panel falling down at a yoga and Pilates studio on the West Coast. And luckily, no one got hurt. But in the event it landed on someone, it would have been a disaster. It would have been very, very, very expensive. New studio, open less than a year. Most of their profit margin and resources would go to resolving this. So this is really why investing in legal makes sense. If you enjoy the episode, make sure to subscribe to Conscious Counsel podcast so that you continue to hear stories like this and get legal information to help you protect and grow your business. And I'm wishing you a wonderful week. And whatever it is that you do, make sure you work with a lawyer who loves you. Have a fantastic week.